Hi, guys. It's a different time of the day, a different day of the week. How's everybody doing? I know that this is kind of, oh, hopefully you guys can still hear me. Hello. Yep. Hopefully, we get some people in here because I really didn't give much of a heads up about this. I wasn't sure if I was going to be going in person or if I was going to be able to stream um, this trial, but essentially the judge allowed for the news to be in there to have a stream so that we could watch. So that is extremely helpful because I do not have pardon me, I do not have press credentials. And I wasn't sure if I was going to be able to take like my laptop and things like that. So um I'm really uh thankful for that. I'm going to go ahead and add the Anthony. Hi, buddy. How's it going? I'm going to go ahead and add the video that I have queued up. Uh, and that way, when it starts playing, we're all good. Now, do I want to share the system audio? I believe that's a yes. Sorry, guys. There's a first time for everything. So this might be a little uh kinky. That's the word that came to mind. There might be some kinks in today's stream. Okay. Groovy. This won't happen if you share a Chrome tab since you'll only share audio from that tab. Wait, what? Okay. So I think I understand what it's telling me. Give me 1 second. Anthony, I was there when this happened. I was at Harry Buffalo, if you know where that is, like not even a football field away from where it happened. And I took photos of it happening. It was wild, so that's why I was like, I have to cover this. Um, I need to add this to Chrome. Give me 1 second. I use a couple different browsers. I'm usually like a DuckDuckGo girl. But it's saying that I'll have a better time sharing this stream if I share it from the same browser. And it's still saying we'll be right back. These are opening statements, guys. So they just seated the jury. In case you didn't notice, uh, Lacey Crisp, who works for WBNS Channel 10 here, she and I have been talking, and I I have every intention of using 10 TV stream, but it wasn't popping up and I was getting a little anxious, so I have Channel 4 stream up just just today. We have like 3 weeks of this, so hopefully she doesn't get too mad at me. But she has been an extremely valuable person to helping me out with this, letting me know what's going on. Oh, that's the wrong it's the wrong thing. Um, Stop screen. Okay. Share screen. And then I think I wanna go like this. Oops, sorry guys. Still didn't do what I wanted it to do. All right, so it should be starting here shortly. But for those of you who are not aware, this is a officer in the neighboring department who responded. He was actually at Kroger's responding to a completely separate issue, and one of the Kroger's employees waved him down and was like, "There's this lady, she just stole a bunch of liquor." And she left the store, got into her car, and it was Officer Grubb and another officer on the scene, and they asked her to get out of her car several times. She was parked in a handicapped spot without a placard. She did not have a license plate on her car. She refused several lawful commands, as you'll see in the footage, to get out of the car. And she put her car in park with Officer Grubb in front of the car, and he shot, and unfortunately, he killed her. What makes this story even more bizarre is the fact that she was 6 months pregnant stealing alcohol. And he had said several times, you know, "Get out of your car, get out of your car." Here we go.
Right here. He has to read a bunch of instructions first, and then what the opening statement is, one of them.
Hot mic.
It's a good thing that they're getting along already.
All rise. All right, go
It
on.
always makes me nervous.
I gotta remember who the alternates are. On the jury. She's an alternate.
All those seats are taken. So, everyone can have a seat. Ladies and gentlemen of the jury, at this time, the court's going to give certain warnings and admonitions. It is important that you be fair and attentive throughout the trial. Do not discuss this case among yourselves or with anyone else. Do not permit anyone to discuss discuss it with you or in your presence. Do not form or express any opinion on the case until it is finally submitted to you. More difficult for you to understand is that you may not discuss this case among yourselves until it is finally submitted to you. You will receive the opening statements, the evidence, the arguments, and the law in that order. It would be unfair to discuss the case among yourselves before you receive everything necessary for your decision. You must explain this rule to your family and friends. When the trial is over, you'll be released from this instruction. At that time, you may discuss the case and your experiences as a juror, but you are not required to do so. Until that moment, you must control your natural desire to discuss the case both here and at home. Do not talk with the attorneys, parties, or witnesses during the trial. Likewise, the participants in the trial must not talk with you. If anyone should attempt to discuss the case with you, report the incident to the court or to the bailiff immediately. You may not investigate or attempt to obtain additional information on this case outside of the courtroom. This would include any research on the internet, in the libraries, in the newspapers, or in any other way. Make any investigation on this case on your own. Do not visit or view any place discussed in this case. And do not use internet maps or Google Earth or any other program or device to search for or to view any place discussed in the testimony. Also, do not research any information about the case, the law, the people involved, including the parties, the witnesses, the lawyers, or the judge by using a computer or smartphone, iPad, or any other device or application that accesses the internet. Or any social media such as Facebook, Twitter, Instagram, and also MySpace. Do not read any news stories or articles in print or on the internet or in any blog about this case or about anyone involved with it. Listen to any radio or television reports about it or about anyone involved with it, or let anyone tell you anything about any such news reports. If you want, you can have your spouse or friend clip out any stories and set them aside to give you after the trial is over. I assure you that when you have heard all the evidence, you will know more about this case than anyone will learn through any media, and or it will be more accurate. In short, you may not investigate or attempt to obtain additional information on this case outside of the courtroom. It is highly improper for any one of you to attempt to do so. Any violations of these orders may cause a new trial or may require a penalty for disobedience. In the event you experience a personal problem, you may explain the matter to the bailiff or the court reporter. The message will be conveyed to the court. At each recess, I will repeat these warnings, but if I should forget to do so, you should remember them and apply them to your conduct throughout the trial. I'm not going to reread this after every break. If at any time you discover that you cannot hear or understand a witness or lawyer, then please speak up so the problem can be corrected. Before we hear the opening statements of counsel and begin to take evidence, I believe it would be helpful if you were to have some preliminary instructions to follow.
We're still getting kinks worked out, apparently.
The counsel, I will give you further instructions covering additional law which you are to follow in this case. It is the duty of the judge to instruct you in the law, and it is your duty to follow the law, as I will state it to you both now and at the conclusion of the evidence. First, it is your exclusive duty to decide all questions of fact submitted to you. In connection with this duty, you must determine the effect and value of the evidence. You must not be influenced in your decision by sympathy, prejudice, or passion towards any party, witness, or attorney in the case. The attorneys for the parties will of course have active roles in the trial. They will make opening statements to you, question witnesses, and make objections, and finally will argue the case as the last step before you hear my final instructions and commence your deliberations. Remember that attorneys are not witnesses, and since it is your duty to decide the case solely on the evidence which you see or hear in the case, you must not consider as evidence any statement of any attorney made during the trial. There is an exception, and that is if the attorneys agree to any fact. Such agreement, stipulation, or admission of fact will be brought to your attention, and you may then regard such fact as being conclusively proved without the necessity of further evidence on such fact. If a question is asked and an objection to the question is sustained, you will then not hear the answer, and you must not speculate as to what the answer might have been or as to the reason for the objection. If an answer is given to a question and the court then grants a motion to strike the answer, you are to completely disregard such question and answer and not consider them for any purpose. A question in and of itself is not evidence and may be considered by you only as it supplies meaning to the answer. As jurors, you have the sole and exclusive duty to decide the credibility of witnesses who will testify in this case, which simply means that it is you who must decide whether to believe or disbelieve a particular witness. In determining these questions, you will apply the test of truthfulness you apply in your daily lives. These tests include the appearance of each witness on the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because it was given under oath. You may believe or disbelieve all or any part of the testimony of any witness. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of the issue. Rather, the final test judging the evidence should be the force and the weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. Also, discrepancies in a witness's testimony or between his testimony and that of others, if there are any, does not necessarily mean that you should disbelieve the witness, as people commonly forget facts or recollect them erroneously after the passage of time. You are certainly all aware of the fact that two persons who are witnesses to an incident may often see or hear it differently. In considering a discrepancy in a witness's testimony, you should consider whether such discrepancy concerns an important fact or a trivial one. This concludes my preliminary instructions to you, and I hope they will be of some assistance to you in listening to and considering the evidence. Please keep these instructions in mind as you listen to the evidence and statements of counsel. I may give you additional instructions during the trial. When the evidence and closing arguments are concluded, I will give you additional instructions on the law which you are to follow. Members of the jury, I would like at this time to highlight the procedure of the trial. First, each of the attorneys will be given an opportunity to tell you what they expect their evidence will be. This part of the trial is called opening statements. The opening statements are not evidence, but they are a preview of the claims of each party, designed to help you follow the evidence as it is presented. After the opening statements, the state will be permitted to present its evidence. Then the defendant may offer evidence if he desires. If the defense presents evidence, the state may present rebuttal evidence. After the evidence is presented, then each of the attorneys will be given an opportunity to make final arguments to you. Then the court will give you instructions in the law. After that, you will retire to the jury room and deliberate on your verdict. With this understanding, the attorneys will present their opening statements. Again, these statements are not evidence, but are what the attorneys expect the evidence to be. Any opening statements on behalf of the defense? Or state, I'm sorry.
On August 24th, 2023, the defendant, Connor Grubb, chose to fire his gun at Takaya Young, striking her in the chest and killing her and her unborn child. The defendant was a police officer with Glendon Township Police Department at the time of the incident. He was on duty, assisting someone who was locked out of their vehicle in the parking lot of Kroger, located at 5991 South Sunbury Road in Glendon Township, Franklin County, Ohio. Another Glendon Township police officer, Sergeant Eric Moynihan, was also present at the scene. As the officers were in the parking lot, Takaya Young exited the Kroger store and entered her vehicle.
With a bag full of liquor.
Kroger employee also exited the store and told Sergeant Moynihan that Takaya Young had just stolen items from inside of the store. Takaya was still in her vehicle in her parking spot. So Sergeant Moynihan proceeded to knock on the window of her car, telling her to get out of her vehicle and that the employee had just stated that she had stolen something. Takaya Young refused to exit her vehicle. Defendant then walked to the front of Takaya's vehicle and drew his firearm, pointing it at her and commanding her to get out of the fucking car. At that point, Takaya attempted to leave the parking lot. Defendant was standing in front of her vehicle near the driver's side. Takaya actually used her right turn signal and began to slowly move her vehicle forward, turning her steering wheel to the right. As she inched forward, defendant still remained standing in front of the vehicle. Defendant actually first placed his hand on the hood of the vehicle. Defendant then took several steps backwards, moving with the vehicle. Ultimately, defendant was easily able to step back into the side of the vehicle to avoid harm, as the vehicle was going so slowly and turning to the right, away from him. However, as defendant was moving back into the side of the vehicle, his firearm still drawn, he shot his gun through the windshield of Takaya's car. The bullet struck Takaya in the chest and immediately incapacitated her, leaving her vehicle uncontrolled. The vehicle continued moving and came to rest after running into an exterior wall of the Kroger store.
The pharmacy.
Takaya Young died that day, as did the unborn baby girl she was carrying inside of her. Numerous officers responded to the scene as a result of the shooting. Efforts were made to render aid to Takaya, but due to the nature of the gunshot wound, she did not survive, and neither did her baby. There's no question that Takaya stole liquor bottles from inside of the store that day. The evidence is going to show that. The state is not going to dispute that. But the state is here before you because absolutely no one should have been killed for taking the actions that Takaya took that day. And as a result of defendant's unreasonable and unjustified decision to stop Takaya with deadly force, he stands accused of the charges that the judge previously read to you. At the conclusion of all the evidence, there will be no question that the defendant knowingly fired at Takaya Young. There will be no question that as a result, she was struck in the chest and died. There will be no question that her unborn child died as well. So this case ultimately comes down to the question of whether or not defendant's decision to use deadly force was justified. At the end of the trial, you'll receive detailed instructions from the court on the applicable law. But the ultimate question for you to answer is this. At the time defendant chose to use deadly force, did he reasonably believe that Takaya presented an imminent threat of serious physical harm or death to himself or to others? And that question is to be answered from the perspective of an objectively reasonable police officer. And after all the presentation of all the evidence, the state is going to ask you to find that the shooting was not justified because no reasonable officer could have reasonably believed that Takaya Young presented an imminent threat of serious physical harm that day. Defendant drew his firearm and placed himself in front of Takaya's vehicle due to an allegation of shoplifting. And even then, he was still able to step out of harm's way with ease, as she was clearly turning away from him and moving her car so slowly. The evidence shows that she was not running over the officer with her vehicle, and that the shot fired by defendant was utterly unnecessary to defend himself. He was easily able to step aside to avoid harm, and avoiding harm had nothing to do with his decision to discharge his firearm. He wasn't defending his life or anyone else's. He was simply stopping her. During the trial, the evidence will show that a typed statement by defendant was provided to BCI investigators. BCI is the Bureau of Criminal Investigations. It's the investigative agency for the state attorney general's office. The evidence will also show that much of what is described in the statement by the defendant as to the justification for why he fired his weapon and killed Takaya is different from what is depicted in the video of the incident. The evidence will also show that after the incident, BCI processed the scene and no firearm was found on Takaya's person or inside of her vehicle. You will also hear from Professor Seth Stoughton, an expert in police tactics and use of force. And you will hear about how defendants' actions were contrary to generally accepted police practices and policies. You'll hear from Dr. Jeremy Bauer, an expert in biomechanics. Dr. Bauer will tell you that based on his analysis of the video evidence, the positioning and movement of defendant at the front corner of Takaya's vehicle is not consistent with the defendant being in imminent danger of death or serious bodily harm. The state is not here to put law enforcement on trial or to condemn police officers in general. The state has profound respect for law enforcement. It is one of the most essential roles in any functioning society, and the state works closely with law enforcement every single day. But no one is above the law either. And on August 24th, 2023, 2 lives were unjustifiably taken by defendant. And that's why the state will ask you to put aside all biases and preconceived notions and follow the evidence to the only logical conclusion. The shooting of Takaya Young and her unborn child was unjustified. Takaya Young posed a threat of serious harm to no one, and no reasonable officer could have reasonably believed that she did. The state will ask you to find defendant guilty of each and every count of which he has been charged, related to the deaths of Takaya Young and her unborn child.
Any opening statements on behalf of the defense?
Thank you, Your Honor. May I have a moment to set up?
You may.
Thank you.
He's lost a bunch of weight. I'll make sure to show you guys the photos that I took from the crime scene. And Anthony, you are correct. I don't know how I missed that. So yeah,
May I have the
I'll cover it.
evidence card, Ms. Cook? I did test this out before while we were on break, so hopefully it goes according to plan here. May I proceed?
May?
May it please the court, Mr. Collins, Mr. Grubb, Mr. Glennon, Mr. Brandt, Ms. Claypool. Good morning. Don't let the prosecutor confuse you. This case is not complex. It's really rather quite simple. The essence of this case comes down to one line. One line that won't be given to you by either one of these prosecutors, and one line that won't be given to you by we as the defense. But rather, the essence of this case comes down to something that you will hear from Judge Young himself in the jury instructions. And that is an immediate threat to the officer or others of serious physical harm or death will permit him to respond with deadly force. An immediate threat to the officer or to others of serious physical harm, a broken back, a broken hip,
Yeah.
a skull fracture, serious physical harm or death will permit him to respond with deadly force. Now, the jury instructions are what you will be required to follow while you're back there and deliberating. And this concept will be in those jury instructions. Now, neither one
Here it
of
is.
these prosecutors will be able to refute the fact that a 3,500-pound car
Human
is
missile.
capable of causing both serious physical harm, a broken back, a broken hip, a skull fracture, They won't be able to dispute that certainly a 3,500-pound car can cause serious physical harm or death. They won't be able to dispute the fact that a 3,500-pound car can be weaponized into a deadly weapon in the matter of split seconds. So why then was Miss Young an immediate threat to the officer or others when she possessed a 3,500-pound deadly weapon with her foot on the trigger, the accelerator? Why was she an immediate threat? Let's talk about it. On August 24th, 2023, you're a police officer. You're working a normal summer afternoon shift. On this day, you were called out to the local Kroger to assist an elderly woman who locked her keys in her car. Parked right next to where you've responded is a car that's backed into a handicapped parking spot. That car has no license plate. It's backed into a handicapped parking spot, and it's got no handicap placard. It's parked in the manner in which somebody may need to get a quick getaway, punch the accelerator, and get out of Dodge. You're no rookie. You know that's suspicious.
I've had to have that done to my car more than once. So I was this way.
A Kroger employee then comes running out of the Kroger. Someone has robbed the store of liquor items. That suspect is ducking into that car with no license plate, no handicap placard, and the one that's parked in a handicapped parking spot, but backed in.
It's like premeditated.
Your sergeant, he's been on the job longer than you, immediately goes over to the suspect in that car. He's standing at the driver's side window of the vehicle. The suspect is refusing to comply with his orders. The officer, your sergeant, Sergeant Moynihan, is trying to de-escalate the situation. The suspect, the one accused of the theft, she's in control here. She can stop the problem.
Too much of a loss for 10. Out of the car. Out of the car.
Now, you realize your sergeant is telling someone to get out of the car. You realize your sergeant may need help, that this person may be charged additionally with resisting arrest, with obstruction of justice, with obstruction of official business. Not only do you realize that your sergeant might be in danger, but there are at least 4 other people in that Kroger parking lot that you can see as you're approaching the suspect and your sergeant. One is a child with a grocery cart, pushing the cart back to the return. Now, as a police officer, you were trained in contact and cover. That when one officer makes contact with a suspect who's already refusing commands, a suspect who very well may be willing to hurt you or kill someone else, that when that officer makes contact with that suspect, your job as a police officer is to cover that sergeant. Where is the only place you can safely cover your sergeant and make sure no other innocent civilians are in the way? of a stationary parked car. Now you'll notice there are no taillights in that car. That car was not moving. That is the only place to safely cover your sergeant and not put any of the other civilians in harm's way. You stand in the front of the car because a reasonable person would see that an officer, a uniformed officer, is not only to the left of your driver's side, but is also standing in front of the car. You stand in front of that parked stationary vehicle because a reasonable person doesn't then start the car, doesn't drop the car into gear, and doesn't proceed to drive that 3,500-pound deadly weapon into a uniformed police officer. Any other position in that parking lot could have put innocent civilians in harm's way, could have put civilians in a position for crossfire should that suspect have had a gun. But the suspect, Mr. Glennon was right, did not have a gun, but she possessed a 3,500-pound deadly weapon and put her foot on the accelerator. That child returning that shopping cart all the way to the left of the screen, she will be the first one run down if this suspect peels out and tries to make a break. That child needs protecting too, so you stand in front of a stationary parked vehicle. Contact and cover.
Car. Out of the car. Out of the car.
7 back in service, 1828.
Your sergeant is to the right. Certainly you can't stand right next to the sergeant and still safely cover him. A Kroger employee is by number 2. And number 3, you can see the top of the elderly woman's head just below that handicap parking sign. The elderly woman who you were just assisting. The other way, here's your view. Again, 4, 5, 6, 7, 8. There are people, innocent civilians, all over this parking lot. Now the suspect is still refusing to de-escalate. She continues to resist lawful orders. She's not free to leave at this point in time. Police are required by law to investigate crimes like these. She needs to be placed under arrest for not only officer safety, but for everyone else's safety in that parking lot. And because you know that because that car has no license plate, if she flees, if she commits another crime in the process, like hitting down that child with
Exactly.
a grocery
They
cart,
wouldn't be able to find her.
because there's no license plate, you as a police officer have no way to track that car down. Your sergeant is about to break the glass on the window to get the suspect out of the car. She's continuing to resist. She's increasing the danger and becoming more volatile.
Get out of the car. Then get out. No. Then get out.
At some point, she starts the car.
Ohio in the chat, guys.
You are trained to know that sometimes suspects in vehicles who are already resisting arrest, sometimes those suspects want to hurt you. You're trained that sometimes police officers get run down by vehicles. Even a slower moving vehicle can still cause a broken hip, a broken back, a skull fracture, a traumatic brain injury if that car bumps into you at a slow moving pace and you fall and crack your head on the pavement. You know this. Then she pulls the trigger of that 3,500-pound deadly weapon. A quarter of an inch push on that accelerator, and that kid returning the shopping cart may be run down. You may be run down. She's coming at you. Her tires squeal. The sound of a peeling out. The sound of a car that's about to go very fast. You try to move out of the way, but it's too late. Her bumper, her moving bumper, comes into contact with your legs. You try to brace yourself for impact and go up on the hood, but both feet leave the ground. And in 1.665 seconds, faster than someone can snap their fingers 4 times, you have to make the decision to defend yourself. You fire just 1 shot. Because 1 shot is all it took to stop that vehicle from sucking your feet under and pancaking you onto the pavement. 1 shot was all it took to stop that car from running down anybody else in that parking lot.
Get out of the fucking car. Get out of the car. Get out of the fucking car.
In 1.665 seconds, you decide to defend yourself, to stop that 3,500-pound deadly weapon from seriously hurting you, to stop that 3,500-pound deadly weapon from sucking you under the car and pancaking you into the pavement, to stop that 3,500-pound deadly weapon from hitting any of the innocent shoppers in that Kroger parking lot on August 24th, 2023. Now, while this is happening, while this is what you're seeing, this is what your sergeant's seeing. Your sergeant is being drugged by that same car. Your sergeant is seeing you, at least 1 foot being pushed backwards. And at this moment, Connor Grubb has not fired. Your sergeant then sees the 2nd foot leave the ground just before he fires. Connor does not fire until both feet are off the ground, until he is hit by the 3,500-pound deadly weapon and both feet are off the ground. Now the car keeps moving. You run to catch up to the car. Comes to a stop by way of the building. You have to get her out of the car. You break the window to get her out. Her foot is still on the gas when you pull her and retrieve her from the vehicle. You realize at that point that she needs life-saving measures. You remember, you've got chest seals in your car. You sprint to your cruiser to obtain these chest seals. Because the job of a police officer, even though you felt like she just tried to seriously hurt you, like she just tried to seriously hurt other people in the Kroger parking lot, the job of a police officer does not stop. And neither does the job of a Marine. So you go and get that chest seal. You sprint to get it. You sprint back to the suspect. And only then do you realize that not only did she put you at risk, not only did she put all of the other innocent shoppers at risk at Kroger on that day, but that she also put her unborn fetus at risk. The rest of the day, you cooperate with law enforcement, you cooperate with your work. The rest of the day, you're praying that she lives, but she doesn't.
Apparently, this is where we enter some murky waters. I'm just going to stop there. I haven't stopped at all. I've been really good. Pardon me. Sorry, my cat's on my lap. And as we've discussed before, I'm allergic to cats. So I'm trying to mute myself when I cough. With that being said, the apparently Connor, the officer, cooperated and went ahead and gave a written statement. This is what the prosecution said during their opening statement, and it does not accurately reflect the video. So we'll have to see what is said in that. But that was the only thing in the prosecution that was said that I think, ow, Coco. All right, she's no longer on my lap. Apparently, I was too loud for her. That was the only thing that was said that was really with all of my research, I had never heard about that. So we'll continue.
Consider what Connor knew at the time.
Shit,
At the time that he was hit by a 3,500-pound deadly weapon.
I will not be stopping the
Connor
stream
Grubb
anymore.
is a decorated Marine. He has never had to fire his weapon at a civilian in the line of duty before. And on this day, he faced every law enforcement officer's nightmare. Now, the prosecution, Mr. Glennon, just came up here and told you Miss Young was not an immediate threat. Their own witnesses are going to tell you differently. So pay attention when those witnesses take that witness stand and tell you that a moving vehicle at you as a police officer can absolutely be an immediate threat.
It's a human missile.
Their own witnesses will tell you differently. Mr. Glennon just tried to tell you that she wasn't a threat. But she started the car. She dropped it in gear. She hit the gas. And she hit a uniformed police officer with a 3,500-pound deadly weapon. And she drug another. She put innocent people at risk on that day. Now, we are here because Connor had the right to defend himself against a 3,500-pound deadly weapon when he was run down and hit, when he was in danger of having a broken back, a broken hip, a fractured skull, when he was in danger of being sucked under the vehicle and pancaked onto the pavement. Connor Grubb had a right to defend himself, and that's why we are here today. Now, remember the law and the burdens and the fact that the prosecutors have the burden of proof. In every criminal case, it starts with the prosecution. And it is they that must prove to you, beyond a reasonable doubt, every single element of every crime charge, including those mental elements. If they prove their case, then, and only then, do you get to our burden. And it's a lesser burden than the prosecution's. It is a feather more than 50%. A slight tipping of the scales, more likely than not. That is what the standard is that we have to prove to you that Connor Grubb was allowed to defend himself. So what two things do we have to prove? Number one, that Connor believed he was in fear, that his life or others' lives were in danger of death or serious physical harm. A broken back, a broken hip, a skull fracture. And we have to prove that by a featherweight more. The second prong that we have to prove is that his decision to use deadly force was reasonable through the eyes of a reasonable police officer, not sitting behind that driver's side wheel, but rather standing in Connor's shoes, perceiving what he then perceived. And we have to do that without the benefit of hindsight. So how will we meet our burden of a feather more than 50%? How will we meet that burden? By a preponderance of the evidence. The first prong, that Connor believed his life or others' lives were in danger of serious physical harm or death. Well, Mr. Glennon told you he did comply with BCI. He wrote a statement and he told them everything that he's gonna tell you. He's going to take the stand and tell you that he was terrified of being sucked up under that car and pancaked onto the pavement. He's going to tell you about his concerns for every other person in that parking lot. And that is how we will prove, by a feather more than 50%, that he believed his life was in danger of serious physical harm or death, and he believed that others' lives were in the same boat. The second prong, that his decision to use deadly force was reasonable through the eyes of a reasonable police officer. Again, not sitting behind the wheel of that car, but rather standing in Connor's shoes, perceiving what he then perceived when he was hit and run down by a 3,500-pound deadly weapon. How are we gonna do that? Well, you're going to hear from an expert witness. His name is Kevin Davis. Kevin Davis has been in the field of law enforcement for longer than I've been alive. He is a former Ohio Peace Officer Training Academy instructor. He taught cadets here in the state of Ohio. He's a certified force analyst. He wrote the book on use of force investigations. He's a trained police officer from this state, an expert witness in the use of force. Now, the prosecutors are gonna call some opinion witnesses also. The first opinion witness that Mr. Glennon mentioned was a man by the name of Seth Stoughton. He was a police officer 20 years ago for maybe 5.5 years in Tallahassee, Florida. He's never been certified to enforce the laws here in the state of Ohio. He's never taught at the Ohio Peace Officer Training Academy. He's never been to the Ohio Peace Officer Training Academy to sit for classes or audit those classes. So keep that in the back of your mind, because he's going to give you some opinions about a case that happens here with a police officer who used lethal force here in the state of Ohio. Keep that in the back of your mind as you judge his credibility. The second opinion witness that the prosecutors are going to call is going to ask that you doubt your senses. You doubt what you see. You doubt what you hear. You doubt your common sense. He too will give you an opinion, and that opinion will be in contradiction to the agents who investigated this case. So again, keep that in the back of your mind as you hold the state of Ohio to its burden of proof. some rules and guidelines in the jury instructions of how you are to analyze this. You will come to know of 3 factors called the Graham factors. They come from a case, Supreme Court of the United States case, called Graham versus Connor. These 3 factors must be analyzed in every courtroom by every jury here in the United States of America. That is what the Supreme Court of the United States has said. Now, the other rule that you've already heard several times by this point, and the judge will instruct you, is that you are not to judge this with 20/20 hindsight. But I'd like to discuss those Graham factors with you.
I think
as
that's
we'll come to
important.
learn them. Number 1 is the severity of the crime at issue. You will hear that driving into a police officer, no matter how slow, if it causes serious physical harm, you can still be charged with felonious assault on a police officer. You will hear that a theft plus fleeing plus some use of force could potentially be an aggravated robbery. You will hear that these 2 crimes are very severe. So we will prove to you by a feather more likely than not, that the severity of the crime, this factor, is present here. The second factor is whether or not the suspect posed an immediate threat to officers or to others of serious physical harm or death. That 3,500-pound deadly weapon hit Connor Grubb. There will be no question that that parking lot was full of people that day. We will have proven to you at the end of the trial, by a feather more, that she was an immediate threat of serious physical harm or death to both Connor, Sergeant Moynihan, and everybody else in that parking lot. The third factor is whether the suspect is resisting or actively evading arrest. You will hear no less than 10 times she was told, "Get out of the car." There will be no question that this factor is also present, and we will have proven that by a feather more than 50%. All of the rules that the court is going to set out for you in these jury instructions that you must follow while you're deliberating. All of these rules will show you, the evidence will show you that on August 24th, 2023, Connor had the right to defend himself because he believed he was going to be seriously hurt. And because that belief is reasonable. Kevin Davis will tell you why Connor Grubb took the action that every reasonable police officer would do. He will tell you why he did what he did. Connor did not set out to hurt somebody, to intentionally hurt somebody on August 24th, 2023. He went to that Kroger because he was doing his job. He was doing his job when he was assisting with a lockout. He was doing his job when he was assisting the Kroger employee in attempting to investigate a theft. He was doing his job when he was covering his partner. He was doing his job when he made sure everybody else in that Kroger parking lot was safe. He was doing his job when he was run down and hit by a 3,500-pound deadly weapon. And an immediate threat, like that 3,500-pound deadly weapon, an immediate threat to the officer or to others of serious physical harm, a broken back, a broken hip, a skull fracture, or death will permit him to respond with deadly force. at the end of the trial, my law partner, Mr. Collins, will come before you and ask that you find what the evidence demands in this case. And that will be that Connor Grubb had the right to defend himself against a 3,500-pound deadly weapon on August 24th, 2023. He will ask that you find Connor not guilty of all of the crimes charged. I thank you for your time.
Ladies and gentlemen of the jury, we're going to take our lunch break now. There's a bus coming at 1:30. You'll need to be back
What?
not to form or express an opinion on the case until it is finally submitted to you. We'll be back about 1:15.
Perfect. Guys. Okay. Working out the kinks. Like I said, it's kinky. They got the interns running it over at NBC today. Yeah, I think they're doing Vadir on I could be mistaken, but it also could just be a scheduling issue, Anthony. I was told they were just going to do opening statements today. Like, so this is new that they were able to get in a witness this afternoon. I was also told, which I don't know if it's been announced yet, that there will be no court tomorrow or Friday. So that's good for me. I had an errand to run, and I don't know if Peter's still in here, but right before I went live, I got a phone call, and I'll have to clip this. I got a phone call right before I went live that I have been accepted for surgery for the malls, the issue that I've been experiencing for the last several months that kept me from going to Boston. It's kept me home like 90% of the time. So there were some happy tears before going live today. Things are really, really good. So for those of you who have been wondering what's going on, I am scheduled for my consultation on January 13th. So she was like, don't freak out. I can almost guarantee you that I'll have a dozen cancellations before then. It's a good thing. It's a really good thing. If you Google, we'll get back to this, but malls. So what I have, it is like every one in, I want to say 100,000. Okay, no. So it's considered a rare condition. 2 per every 100,000 people. So in order for me to even be able to see him, I had to send over years of tests. I had to go through so many stupid tests. Like they did an ultrasound of my carotid artery. They did a nuclear food study where I ate radiation and they watched it go through my stomach to see how fast I digest food. I was up last night throwing up. I mean, it is completely taken over my life. And because it's so rare, doctors often look for deer, not zebras, right? So let me get rid of this. Sorry. So like I I had to go through a bunch of hoops, and only 15 surgeons rather, in the United States performed this operation because it's so rare. And I was so lucky to find someone in Cleveland. I thought I was gonna have to go to Connecticut. Um, so sounds delicious, right? Um, anyways, I was really excited. It it would be great if I could have the surgery before the end of the year. It just depends on cancellations, and he's pretty quick to book after our initial consultation. So, with that being said, sorry, I know that was a little bit of a pivot from what we were discussing, but I've had so many people ask me about it, and this literally happened right before I went live. So, really, really good news. I haven't even told my mom or dad yet. So, if you're watching, yay. Hopefully, I'll be better next year. No, Anthony. Anthony asked if there was anyone in Columbus, the capital, who does this surgery. Get this, Anthony. There's not even anyone at Cleveland Clinic that does this surgery. It's through another hospital in Cleveland that I have to go through. And which is like what I wanted, it's robotic. So it's laparoscopic still, which was huge because a lot of the doctors will just straight up cut you from like your clavicle all the way down. And I was like, F that. I mean, right? When you can get things done laparoscopically, it makes no sense to open your thoracic cavity. But to make it even better, this guy does it robotically, and um I'm so happy. I'm so happy, and my insurance, he's in network. Oh, the only positive to having it done next year is that I'll immediately start the year off hitting my deductible, but I will have to pay out of pocket quite a bit of money, and that's okay. I mean, uh considering the fact that I've lived in this house 24/7, with the exception of like one day a week, that's been really rough. So I'm really excited to get back to normal. Um, Speaking of getting back to normal, I I really didn't say hello. Hello, everyone. I've had Peter in here and Anthony chatting with me in the chat over on YouTube. If you are watching, please make sure to say hello. Uh, if you are too shy, if you could at least like this stream, retweet it, share it, and what would be like extremely helpful would be if you could please subscribe to my YouTube channel. Um, I think we're going to gain some traction with this trial. So bring in some new people, some new thoughts, ideas. That'll be great. And my thoughts about that is simply because I haven't seen anyone else covering it. And unfortunately, I know I'm kind of jumping around here. As you guys may have seen when I was playing the defense's opening statements, they the defense is I just lost my train of thought. Oh, I know what I was going to say. Since this isn't being streamed on like um lawn crime or court TV, I can't pause it, say something, and just like start from there. It automatically like speeds up to where it's at in the moment. So I'm not going to be able to stop and chat. That's also a good reason why I need to have a notebook out. I didn't grab one. I figured I would use my laptop here. But on the other hand, I don't want to make a whole bunch of typing noises. So I digress. Um, we're learning. There's going to be a couple kinks along the way that we're going to work out. It's going to be a good trial though, and I'm really looking forward to spending this time with you. Heads up, I am supposed to go visit my dad. I haven't seen my dad in like 2.5, 3 years, which is so weird and not normal. And I don't know what's up with that. He lives in North Carolina. I'm supposed to go see my dad in 2 weeks. So we're gonna have to see how this is going. I did buy the tickets that I could change dates um in case something came up. I don't know. I had this like gut instinct that I shouldn't just buy the cheapest tickets. I should buy the tickets where I can change flights if I needed to. I don't want to, but if this is going well and you guys are enjoying it, then I'm probably going to um extend my or not extend, postpone my trip for like a week. Maybe the week after Thanksgiving. So, surprise, Dad. We'll figure it out. We'll figure it out. Uh, what else? My nephew's down there this week, so he's being kept busy. Um, every day court will start at 9 a.m. That is my understanding from my contacts that I have over there at the courthouse right now in person. What did you guys think? What did you guys think of those opening statements? I'll tell you, I was very underwhelmed with the prosecution's opening statements. I really thought for this to go to trial that we were going to hear some craziness. Like we were going to find something out from the prosecution that we didn't know. The only thing that I think that we found out was that there appears to be some inconsistencies when it comes to the written statement versus the video. I have no idea what those inconsistencies are, but I can tell you firsthand that trauma is a weird thing and people react differently. Sometimes it takes hours, sometimes it takes days for you to really snap out of it. And so I don't take, for instance, Karen Reed saying, "Did I hit him? Did I hit him?" I mean, like it's something that will it's something that I really connected with in a weird way. As no, I have never been in any situation remotely close to that, but I've said things assuming the blame um in moments of crisis and blame and guilt and trauma, all those things. So, I get it. It'll be interesting to find out what those inconsistencies are, but Anthony said the defense was great. Uh I I agree with both sentiments. I think that the prosecution uh how do I put this? Um I think he was very nervous. I don't know how many cases he's tried, he doesn't look familiar to me, but then again, there's a constant flow of prosecutors uh because it's not that great of a job and the pay is horrible coming off of those loans that you took out for law school, right? Um so I, I don't know, he just looked a little scared, new, and maybe a little like lally now that I think about it. Like he didn't I mean, didn't come off strong whatsoever. But I'm willing to give him grace and say maybe it was nerves. Maybe he'll step it up. Um, do you mean that, Anthony, you said you think the defense will step up? Do you mean the prosecution? Or I think the defense has already shown that they're going to knock this out of the field, like, or ballpark. I think that they've shown uh, that they have gone through every millisecond of, yeah, he meant the prosecution, millisecond of the video footage, every written word, all the witness testimony. I found out that a few of my officers are going to be testifying because they responded to the shooting. Because it's right on the line of my city and that city. So I'll see some friendly faces. What else? You're good. I knew what you meant, buddy. He said my bad, my mistake. Um, I do you guys want to see the photos? Let me figure out if I can show the photos that I took. Thank you for liking the stream. I love you guys. Please keep it up. That helps me tremendously. Not for ego. It just helps push out the algorithm so that more eyes get on it. And I have um a lot of followers from law enforcement. I have a lot of followers who believe in um reforms that need to be made within law enforcement. I have a lot of advocates, people who are interested in policy following me. So I think that we can have some really interesting conversations here. But the first, I found out about this case because I was essentially there. There is a 4-lane road. They mentioned this in the opening statements, Sunbury Road, um, that separates the area I was at from the area where this took place at. Um, I heard everything and I immediately ran outside of the bar that I was at. Oh, tornadoes. If you know, you know. I'm sure Anthony knows what I'm talking about. It's noon on Wednesday. We get tornado sirens. Do you guys hear them? It's what a tornado siren sounds like if you didn't know. Okay, let me pull up my photos. Yeah. He heard it. Yeah, It's what we do in Ohio on Wednesdays at noon. Always test the sirens, and I think that every state should have that. A lot of started going off again. A lot of places, even some places, in Northwest Ohio, I don't think they do it except for, like that one was really loud, except for, like, once a month, and even then, I think that you should always test them, like, on a regular basis. The only time that they won't go off is if it's a Wednesday and we're expected to have severe weather that day, like, they won't run them that day, but they'll let you know, like, you'll get a bunch of messages, "The sirens won't be going off today at noon." I think just because Ohioans live by these sirens. Alright, let me share my screen with you. Okay, so I will decrease myself so that you can see this. Let me pull this up on big enough screen so I can. Okay. Can I like increase this view? Zoom in. Okay, that's what I thought. Okay. So I don't know how well y'all can see this. And maybe you'll be able, if you're not able to immediately like zoom in, maybe you have to take a screenshot and zoom in. This is it shows the date and it shows the time. And you can see the highway road that separates from where I was to the grocery store where this took place at. Let me get my other photo. Okay, I'm able to zoom in here. Okay. Whoa. Sorry. I'm my screen is okay, now we're good. We're good. Metadata is a thing. Listen up, Massachusetts. I'll get that off the screen. I recognize it's blocking the photo, but I don't understand metadata, so I just went into my Google Photos and I I saw like the photo and made sure you guys could see the use me of making this up. Although I think it would be pretty difficult even with AI to make up this photo. If you look closely, I felt like I was able to see it. So I'm able to zoom in on my screen and I'll walk you through what I'm seeing. Give me just 1 second. Okay. So, why is my computer doing this? Stop it. All right. So, you guys can see my mouse clicker. So, this is the top of it's a light bar on top of a cop car. This is one of the London Township cop cars. That is the responding agency from this event and who Officer Grubb, Connor Grubb, worked for. Where I think this is important, you see the crime scene tape here. If you guys saw what I was working with, for some reason, the photo, my StreamYard, it's like very tidy. Okay. So you see the crime scene tape right there. This is, I believe, the coroner's vehicle. And her car, I believe it is this one right here, where I am circling. And it's weird that I took a photo. I can tell you, when I started listening to not listening, but seeing information go on X and Facebook about this event, like within 30 minutes, I automatically did not like what I was seeing. That a cop shot a woman, and then, people were like, she was pregnant, she was pregnant. She was 6 months pregnant. She was stealing alcohol, 6 months pregnant, getting into a vehicle without a license plate, backed in a handicap spot without a handicap plaque. As someone who has very much depends on my handicap placard when I have flare-ups, like, that's really annoying, you guys. If you do that, don't. It's just like a dick move to do. Yeah, this is about, Anthony said he's about 15, 20 minutes away from this Kroger's. I am about 7. So I was across the street. Originally I thought I was there for trivia, and then I saw it was on a Thursday. Trivia is not on Thursdays. So I believe that I was there for a game. I would assume it was baseball. I cannot be for certain though. Um, but yeah, I took the photos. I didn't like that on the scanner, because I'm a loser and I bring my AirPods with me in case something like this happens, and I'll pop one in and I'll listen. And on one hand, I was hearing that um someone attempted to hit an officer, and this officer whipped their car, and the officer shot, um and I was hearing that, and I was reading through social media that this poor pregnant woman was shot and killed by an officer. So, yeah, it was annoying to me immediately. So I was like, you know what? I'm going to take a photo. I doubt anything will come out of this, but I'm going to take a photo. And I'm glad that I did. You just, you never know, man. I think the defense did a great job saying what I believe to be true. They told her no less than 10 times to get out of her vehicle. And because of they had enough situational awareness of what was going on around them that the officer who ended up having to shoot, he was in front of her car, and he I mean, they kept saying, don't shoot, or not don't shoot, get out of the car, get out of the car. No one ever said don't shoot. And it she didn't get out of the car. She said, I refuse to get out of the car. I didn't steal shit. Those were her words, not mine. She said, those girls over there were stealing. I'm not getting out of my car. This continued on and on and on and on and on to the point it should not have even been a conversation. And that's interesting, Anthony, that you hold this perspective considering that you worked at loss prevention. It's super interesting because I feel like it was a right to shoot. Like I think that e especially knowing now that his sergeant who was with him was getting drugged by the vehicle, and all the other extenuating circumstances, like there were kids with shopping carts. The little old biddy was in the car next to them trying to get her keys. She locked in her car. Been there, done that. And Westerville has helped me blend in too. Um, just knowing that this officer, I can't imagine what it's like to take a life. It must be one of the most horrific things that you can go through as a member of law enforcement. And it comes with the job, but with that being said, um, you are taught that if you are going to be injured after giving lawful commands, if you are um, in a position to make an arrest, you need to make that arrest. And like hindsight being 2020, what she said not to do, there were no plates on the car, so they wouldn't have been able to find her if he had just moved aside. And um that's just how I'm going into this case. I'm open, as always. I'm open to hearing different perspectives. I have always been a very strong supporter of law enforcement. Um a lot of you guys, if you've followed me for a while, know that. It was just, what is going on? Hold on one second. Stop sharing. There we go. I don't know. I don't know how we're at trial right now. Anthony, who worked in loss prevention, he's wrote they weren't allowed to follow people out to the parking lot because only stop them as soon as they get out the first step of doors. Okay, so you were only allowed to follow a suspected shoplifter to the front set of doors to stop them. That sounds about right. Um, Anthony, did you hear Anthony just asked, why get in front of the vehicle? The sergeant was on the side. There was a Kroger's employee on the other side of that vehicle. And they were backed into that position, and the sergeant was trying to de-escalate the situation. You know what? I can pull up the video right now. Let me pull it up. One moment, please. No, I don't want to show that because that's not going to show the whole picture. This made it on CBS Evening News. Okay. So I'm going to start off first by showing you guys the surveillance footage. I think that's a good place to start. Give me one moment. And let me make myself small so you guys can see. Oh, yeah, there wouldn't be any sound because it's surveillance. So she looks to see if a teller is paying attention. She looks directly into the camera. Right? She did right then. It was really quick. Do I have this on speedy? Like 1.5? No, I don't. And she took that bag out of her purse and started stocking it with liquor. And if you've been to this liquor store, it is very small. I would feel very uncomfortable shoplifting in this area. Just saying, like, this was ballsy. Gotta love the parent with the kid in the liquor store. And these are her friends. She's definitely waddling like a pregnant lady. They couldn't back her in because she was backed into a space that didn't have, like, it had a concrete barrier behind it. So, because it was a handicap spot. So, it wouldn't have, you know what I'm saying? in that, if you've been to that Kroger's, that parking lot's really slim. So here she is. They're not gonna pay for anything. Going through the doors. All right. All right. So let me find the video from the shooting. That was loud in my ears. Hot damn.
Now, breaking news from NBC4.
That breaking news, we are getting our first look at what led to a deadly shooting involving a Blendon Township police officer and a pregnant woman. Thanks for joining us. I'm Jennifer Bullock. We are going to walk you through this video, but we do recognize not everyone wants to see this. So we want to warn you, some of these images will be disturbing. Now is the time to mute the television or leave the room. Today's body camera release comes 8 days after Takaya Young was shot in the Kroger parking lot on Sunbury Road. On August 24th, Blendon Township's police chief John Belford says the 21-year-old was one of several people stealing alcohol. When police were alerted, officers say Young was in her vehicle and was asked several times to get out. Police then say Young put the car in gear and drove toward an officer. Chief Belford says Young was given aid on the scene, but later died from her injuries. Once again, we are going to show you that video from the police officers from that night, and we are bringing you team coverage
with Takaya Young approaching. Yeah, Jen, what we are going to show you is body-worn camera footage from each of the two officers who were involved in that incident last Thursday.
You know what?
Each video
Hold
is
on.
just over one.
Uno reverse card, because this is it's not, it doesn't show the whole video. You know what I'm saying? Like, it's just pickings of the video. Let me Okay. All right, I found a better one. Sorry, Stream Mama. You came in during a pretty intense moment. See? Doesn't matter for what. Is this whole thing in slow motion still? Oh, there's no volume? Hold on. Could you hear volume on that part? Because there was no volume during this slow motion one. Damn. All right, hold on one second, guys. Let me remove this and re-add it. Okay. Damn, all this time? Shit. That was very lazy of me, though. All right. Let me start it over. Let me, make sure to let me know if you can hear it, because there is volume.
Attention 29, 3705 Managua, 3705. A female is hallucinating. Too much of a house for attend.
Out of the car. Out of the car. Out of the car.
Thank you.
Out of the car.
7 back
Doesn't
to
matter
service
for what.
1828.
Do not leave. Get out of the car. Then get out. No. Then get out.
Get out of the fucking car.
Get out of the car.
Get out of the fucking car.
Get out of the car.
Shots, your shots fired.
Shots fired. Stop the goddamn car. Stop the goddamn car.
We're going to have a 34 on the couple now. He's going to be at.
No, that's the bag of liquor that she has on her shoulder. That's the same one. This doesn't have audio. This does.
3705 Managua, 3705.
What's
A
that?
female is hallucinating. Too much of a loss for attend.
Hey, stop. Hey, out of the car. 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 They said you stole stuff, do not leave. Get out of the car. Then get out. No, then get out. Get out of the car. Get out of the car. Shots fired. Stop the goddamn car. Stop the goddamn car.
Well, he's going to be
There it is.
It's just so dumb that, like, putting yourself in this position. Oh my God. Our woodpeckers are back, Frank.
Hey, stop. Hey, out of the car.
Oh, shit.
Out of the car. Out of the car.
We have volume again.
Out of the car. Out of the car. They said you stole stuff, do not leave. Get out of the car. Then get out. No, then get out.
Get out of the fucking car.
Get out of the car.
Get out of the fucking car.
Get out of the car. Shots fired. Stop the goddamn car. Stop the goddamn car.
There's no volume. Or audio, rather. So that's intense, right? Kind of put the damper on it. But that's what we are in court for. So court is going to be back at 1:15. And I am going to put trying to find out how I can put a comment on the screen. Court will be back at 1:15. I guess I could just change my name. Yeah, this is where I live, Stream Mama. So it'll it's unfortunate. It's unfortunate that a woman had to lose her life. It's unfortunate that um that Officer Grubb is in this situation. Um but I was across the street when it happened, which is why I said that I was going to cover this trial. And it's been a long time coming. It happened August 24th, 2003. So, yeah. If you guys are interested, I am going to put words on stream up for you to play. You have to be on YouTube. So all you do is type it in, your guesses. It's a lot of fun. I am going to go ahead, walk away. I'm going to mute myself. And I'll see you guys at 1:15 or a little bit before then. I'll come back and just like debrief people. But like I said, if you do want to play the words on stream, you have to like watch it on YouTube. You can't be watching it on X. So it's a lot of fun. So come on over to YouTube. Howdy. Okay. All right. I have my notebook for notes. Duh. And I put on a heating pad because my butt hurts from sitting here. And I let my puppies out and I made lunch. What did you guys do? Did you guys have lunch? Let's go ahead and get this going. Stream Mama's working. Yes. All right. What does that look? No, I don't want to do that. I'll go back to this for the time being, but we'll switch that up once court resumes. Friggin' arthritis, man. Stream Mama, I need to have Jack write my intro song for YouTube. I messaged him like forever ago, maybe during the summer. But I know it's his busy season with everyone going down to the Keys. Yeah, you did get back just in time. You know, I just realized that I was supposed to hang out with my mom today and she hasn't even called. I think we were supposed to like go to TJ Maxx. I don't know. But she did buy me turkey breast, so I do need to collect some groceries for her. She bought me turkey breast and lettuce because there's a turkey breast at this Kroger's near her that I can't get at my Kroger's near me. So dumb. So if you are new, hello, welcome. court should be resuming here shortly in the trial of with the state of Ohio against versus Officer Connor Grubb. He is being charged with murder. There was a manslaughter. I don't know the specific manslaughter charge, but and then felonious assault. And this took place in August of 2023, and I happened to be across the street when this happened. And so I have been following this case closely, and I decided that I was going to cover it. And we were only expected to have opening statements today. So this is surprising that we're already starting with the prosecution's case at 1:15. If you wouldn't mind, it would help me tremendously if you could like this stream. If you are enjoying your time here, if you could share it or repost it, retweet it. And if you're just a good human being, it would be great if you could subscribe to my channel on YouTube. That's what we do around here. Guilt you into it. The trial is expected to take upwards of 3 weeks. And he has a defense team that has worked on other police, specifically Columbus police trials. So it's interesting to see the same faces up there. And one of my viewers, Anthony, brought it to my attention that there is going to be another trial coming up here in Columbus in December that I'll have to make sure I cover as well, because I don't know how this is not double jeopardy, but because it was a hung jury, I think. God, it was so long ago. There was another cop. And man, I could have sworn he got off on at least one of his charges. I'll have to go back and look. Too much going on right now to dive into that. But the name is Jason Mead, and I will have that trial for you guys in December. So yeah, it's a lot of cop stuff here in Columbus, Ohio, unfortunately. No one likes to see that. But I feel a certain way about this case. I don't know about you guys. Hopefully you'll tune in and be able to come to your own educated opinions about this. Because these are some pretty serious charges. Got quite a few people watching over on the twit-twat, as the Danish man says. I haven't checked YouTube. Oh, I remembered while I was making my peanut butter and jelly sandwich that peanut butter jelly time. Sorry. I also took my ADD medication. So we're good. I was reminded that one of the things I was starting to talk about, forgot, is I can't stop and comment. So I'm just going to have to take notes. That's why I brought the notebook over here. So no, I did not have a ham sandwich. No ham sandwiches for me, Anthony. How about you? Did you get a ham sandwich? Oh, I took all my puppies outside. They were very excited. And I went up to brush my teeth because God forbid I have something in my teeth. My toothbrush didn't work. It needs charged. And all my puppies were snuggling like 3 little piggies in my bed. It was so cute. Because usually they're barking at each other. You just can't make that up. You can't make that up. I awoke the beast. You know what? I have ordered Little Caesars quite a bit in 2025. And every single time it has exceeded my expectations. And I consider myself a pizza snob. I really do. I don't know what they've done in like the last 10 or 20 years. I don't know the last time I had it, but like they've gotten better. It's so good. So that sounds delicious to me. I like how I can get it DoorDash, or have it DoorDash to me at like 1 a.m. on a Saturday. It's great. Riley. He's 14 and he has doggy Alzheimer's. And so it's usually around 3 o'clock that he starts to like get really antsy and doesn't know what to do with himself. Court's not on, by the way. But I think since I'm up and moving today and I have a bunch of lights on, he's like right awake. Right awake. What do you get on your pizza? From Little Caesars, I like their like crust. I got stuffed crust, which is not normally something I would eat, but that was really good and it had like a certain flavor. I don't know. Like buttery garlic. And then I just get extra cheese. I like pepperoni though. I don't know why I don't get it. I just don't. Speaking of pepperoni, Jersey Mike's sounds delicious. I love Jersey Mike's. There's a Jersey Mike's right next to that Kroger's on the other side of the dollar store there. Unpopular opinion. I don't like pizza. That is a very unpopular opinion. But I do love Pizza Hut stuffed crust. Okay, girl. I love Pizza Hut pan pizza. I think they are the bar when it comes to pan pizza. It's like buttery and crispy. It's my jam. Like, love it. But I texted my husband last week and I was like, I think I could have Pizza Hut pan pizza once a week. And he said, no, thank you. Yeah, I would eat pizza every day. I have eaten pizza every day. I used to work on campaigns. I was pretty chubby. All right, here we go. Oh, I gotta change my name. Change my name, change my name. Excuse me. And my husband likes their stuffed crust. Stream mama, so you're not alone.
Let me know you're going on the field trip.
Oh, are they down the street right now? No.
Everyone can have a seat. Ladies and gentlemen, at about 1:30, we will be, you will be doing a jury view. And at this time, counsel for the defendant has waived his appearance. That's the reason he's not here in court today, for the limited purposes of going on the jury view. I need to read you an instructions. You're going to be taken to the premises or scene involved in this case. You will be required to remain together under the supervision of the bailiff until you return to the court. Counsel and the parties may be present at the time, but they may not discuss the case or demonstrate anything relating to it. The bailiff may point out certain things to you. What you observe at the scene is not evidence. Since conditions may have changed since the time of the events in this case, the evidence as to the physical appearance of the scene must come to you from the witness stand. The sole purpose of this viewing is to help you understand the evidence as it's presented to you during the trial. And once we get, once you're done with the jury view, we will break. You can go home. We will start back up Monday morning. You can be here by 8:45. Are they checking in here or? Okay, so you'll check in with the jury commissioner downstairs on Monday morning at 8:45. We're going to try and get started by 9. And do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. And we'll see you Monday morning. Have a good weekend.
Okay. Let's see if they say anything outside the presence of the jury. I don't think they're gonna. Well, I guess that makes sense. I don't know why I didn't think of that. But I was right about there being no court tomorrow or Friday, which is great. And yeah, if you guys have any questions, feel free to let me know. Otherwise, I might go take a nap. I should probably call my mom, see if I'm meeting up with her. But I think that you guys, yeah, they're back on Monday. I think you guys are really gonna understand why I decided to feature this trial. I mean, hypothetically speaking, I'm not gonna go take my phone over there and show you guys the jurors, but I could stop by there sometime this week and show you guys where it happened, because it's not that far of a drive. It's also a really pretty day outside, so not sure what I'm gonna do with the rest of my day, but I appreciate you guys hanging out with me for the last almost 3 hours. And I will see you guys on Monday. I'll probably have the stream up and going around 8:50. Yeah, then I'll absolutely take my phone over there and show you guys where this happened at. And because I have a handicap placard, I can back into the spot and show you guys what it was like. Yeah. So if like anything between now and then, please feel free to let me know. Comment, whether it be on X or on YouTube. Overall, I think it was a good first day. A little kinky, like I said, getting those kinks out. But yeah, I've always just highlighted cases every Thursday night. I've never sat all day. So this was a change, but we'll get there. Practice makes perfect, right? So I can upload that to YouTube probably by this weekend, and to X. Maybe not X, probably just YouTube. So if you are interested in seeing that, take a peek over there and turn on your notifications. Oh, okay, Anthony. I'm like never on Facebook, but I will check. And let you know somehow. I can't check right now. But I can check on Monday. Yeah. So I hope, like I said, I hope everyone has a lovely, lovely weekend. I know it's only Wednesday, but man, does it feel good saying that. And this is fun. Let's do it again on Monday. Bye-bye.